Good afternoon, everyone, and welcome to our webinar this afternoon. First, we'd just like to remind everyone to put your phones on mute so we can cancel out any background noise or potential interference, and feel free to turn those back on afterwards when we have our question and answer period at the end. Today's topic is Start to Finish, Psychology and Family Law. And for those of you not familiar with us, Linda and I are forensic psychologists and co-founders of a company called Child Custody Analytics. And our website provides on-demand access to psychological information, research, and expertise. And it's really an illustration of an idea that came to us 2 years ago after witnessing the difficulty that family lawyers, professionals involved in family courts, and court officers themselves had difficulty accessing psychological information. And our solution makes this flawless, seamless, and effective, and provides a solution that we're going to describe a little bit today. We'd like to first open up the conversation and discussing really what are we talking about with family law. And we've come up with this idea of family law being a triad of expertise, that it really addresses the legal piece, the financial piece, and then today's topic, of course, being the psychological piece. And the common theme that we hear from family law professionals and parents in the family court system over and over again is not having access to the psychological information. And the way that this positions and pivots into the arena of the triad is, if you think about these various technologies that are available to family law professionals and mostly attorneys, but not available to parents and not available to people without having a specialty knowledge of this information, is having family law software to do financial research, of course having Westlaw or LexisNexis for their legal research, and we see ourselves as filling the gap with psychological research by, again, completing that triad of services to really advance the issues so that the expertise is rounded and covers all three areas.
And I'm just going to add just an extra point to that slide, which really is, I think as being someone who's not a lawyer and looking at family law, I always think of family law as really just you need to have a specialized understanding of families, just as a corporate lawyer should have a specialized understanding of business, or an environmental lawyer of environmental science. And so it's really just looking at family as being the crux of that legal solution and that legal service. And that's what we hear a lot from the clients we interface with. When we kind of talk about the legal trends, I think we've been doing a lot of looking at this piece of the equation just because now we're clearly in that marketplace. And it's actually been fascinating to see the transformation of law over the last few years. And again, looking at it from an outsider's perspective, clients are definitely coming in with this belief that they really know everything now. The online world, as great as it can be and it offers such positive solutions, there are some downsides to it. And one of it is this kind of idea that you can get access to any information anywhere. And by clients, having this information, they believe they really know it all, or they know more than the experts, they know more than the counsel that's available to them. And so clients are coming in, from a different position than they were in 15 years ago, when they didn't have that ability to connect with other individuals who were in the legal system. They didn't have information, research, but now they can do it all. So it's really creating, some havoc for, I think, most professional fields, but in particular, you really see it in the law towards this kind of new way of doing law, these new digital solutions, and seeing a lot more clients self-representing.
The other component to this is talking about some of the industry disruptors, and we would be remiss if we didn't point some of this out. And just as we've had technologies where they're described in the media as version 1.0, version 2.0, and Web 2.0. We really think about this in a way of family law disruption 1.0 and family law disruption 2.0. And the way we've categorized it is really looking at the first disruption taking place with unbundled services, where everyone was really in an uproar with not only just the notion of unbundling services, but then those services being unbundled and practiced by lawyers who did not have their expertise in family law. They were experts in bankruptcy and other kinds of laws, and they were just jumping in. And that created a lot of instability in the marketplace. The second version of family law is a wave that we really saw as a bit more litigant driven. And this gets back to that emotional piece about what are clients doing when they're dissatisfied and they're not feeling understood, and how are they reacting and behaving to that, and how is the market in turn responding to that behavior and responding to that need. And here's where we have the gap, and a number of companies such as LegalZoom, Weavorse, Avo, Rocket Lawyer have come into the marketplace, and they're really the wave of disruptors that are filling that need. And they're pitching, as you see on the logo, everything you need to know. And they're providing digital disruption, which is now clients don't even have to leave their home to get legal counsel and advice and potentially get some kind of a connection that they perceive as being absent in the relationship aspect with the traditional way of providing family law services. The battle behind this is also some of the funding. So just as an example and as an anecdote, Rocket Lawyer is a new digital company. You may not have heard of it, but they just got a round of $40 million in funding, and it's not their first one. So this is an example of a trend that we see as continuing to fill the marketplace and something to be aware of.
So shifting a little bit just to psychological information and how it's generally been used in the past, probably the primary concern we've heard over and over again is really this inability to access psychological information and expertise. So when we have talked to the lawyers that we know that are colleagues of ours, it's been frustrating. They often have to resort to online searches for information, or they need to hire an expert. And, the reality is most cases can't afford an expert. And even if an expert gets involved, it's really towards the end of the case if it's a litigated, contested case. But the reality is when you look at psychological information, it's really something you can use up front and proactively to really help to manage the case and be in control of the case. So, that was really what started our idea of making sure there was just an easy solution out there to get some of the expert information. I mean, Eric and I are constantly repeating a lot of the same information over and over again, and clients can't continue to pay for these really expensive services. So, the online world and the digital world really allows a transformation of how that information is provided. So the idea, again, is just to try to get the highest quality information you can get. And again, even if it's through an online search, it's going to take you a little bit longer. It's probably going to be a little more unreliable, but at least it's there. There's information available.
So with your email, one of the documents that we sent you is this form called Strategic Case Planning Psychological Areas. And we constructed this form, number one, it's a tool for you, so you've got it in PDF format, and you of course can print it out. In the digital format, if you hover over the specific topic areas, there's a pop-up window that gives a definition. You can play around with that, but it's really to cue up thinking and brainstorming about psychological areas. And the reason why we did it that way is when we've met with lawyers, they've shared concerns about there being sort of this divide with sometimes understanding the psychological language and sometimes the translation of that language. So this is a way to assist with that and to really create a template for a strategy, how to think about the psychological areas in each particular case. And checklists is kind of in line with the bestseller, the Checklist Manifesto. If you've got a checklist, nothing will remain undetermined or unknown with respect to the particular case. The idea behind this is that you can use this proactively. And with this particular form, you can start to think about how you're going to be using strategies, interventions, motions, information, and specifically in today's example and what we're going to get to on the next slide, psychological information, to really work your case from start to finish. So we're going to give you two examples of how to use and apply specifically at a very granular level psychological information, whether it's research, whether it's a digital document, whether it's a bundle of a topical summary such as relocation. And we're going to give you this example, which is an example on a contested case, and then Linda's going to describe an uncontested case. So if we follow the flow chart on the left, we're starting with a topic of a case that's coming in with addiction. And really, when you think about addiction, there's a lot of different nuances, and every case is slightly different. But there's different roles that the lawyer can take in addressing this issue, whether you represent the client who has the substance abuse problem, or whether you represent the client who's alleging the addiction of the other parent, or if you're in fact the guardian ad litem and you're looking at best interest issues, which challenges you not only to look at both points of view of the parents, but to really understand and be the most informed about addiction, so you are safeguarding the child appropriately and making appropriate treatment recommendations in an area which may not necessarily be your specialization. So if we think about the different roles of an attorney on this type of contested case, there's what we always like to talk about is the counselor at law component, which is the client education and being able to meet with your client, inform yourself first, and then inform them afterwards. And this is a session, again, as time goes on, where it continues to be an ongoing learning opportunity, and your client really comes to learn to appreciate you as being the subject matter expert. And rather than sending them for a consult with a mental health professional or downloading a particular book, this is a quick, simple, easy way to really get them some initial information up front to help them participate in the planning so that you can ease their concerns. The next aspect is court preparation. So one example of court preparation is there's often a request for drug testing. So how does psychological information inform on this? Well, you need to know what kind of drug testing you're going to request. Is it going to be a urine test? Is it going to be a hair follicle test? Is it going to be an expanded panel drug test? Is it going to include ETG, the metabolite for testing alcohol? So these are all examples of, again, being informed, using psychological research to inform your legal petition, whether it's in the form of a motion, whether it's a stipulation, whether it's a treatment agreement, etc. Next is case management. So again, how are you going to manage the case? So in the example of addiction, this is something that's dynamic. It's almost never static, where someone walks in with an addiction and then it's resolved in 14 days. So again, it's thinking about how are you going to manage the treatment and how should you strategize around any kinds of treatment referrals and treatment outcomes. And this is an example where being informed with psychological information helps you understand the differences between those various treatment modalities. So, for example, recently an attorney called me up and asked about, what's the basis for recommending group therapy versus individual therapy? What's the basis for recommending a partial hospital program versus an IOP versus residential? So collectively, this is where you can come in, again, being informed. If you're guiding the client who has the addiction, you can help them make a sound decision that's research informed. And if you're representing the parent who's concerned about the addiction, you're giving them information that will help them be at ease, knowing that their concerns are being properly addressed with good science. And then, of course, the last example is trial preparation. And needless to say, psychological information will inform not only the strengths and merits of the case, but also point out the particular liabilities that may be relevant, that can be drawn out in areas of treatment, impact upon the child, drug testing, outcomes, and then, of course, harm reduction versus abstinence. So specifically meaning that there's some cases where abstinence is the desired outcome for an addiction case, and then there's other instances where a harm reduction, where you're really just looking for an outcome where somebody is driving their addiction into a degree of usage patterns that's non-problematic, non-abusive, and definitely not during parenting time.
So I'm just going to add a couple of points just up above on client education and court preparation. So just as an example, and this has come up regularly in some of my cases, is, you can often have a client who comes in and expresses concern regarding their soon-to-be ex-partner, regarding, for example, their alcohol intake. And they'll come in and state, I believe my partner, is an addict, is an alcoholic. And if you can get information from your client around their partner's alcohol intake, for example, and really use the psychological information we have to understand, is this really a problem? Is the reported drinking at a level which warrants concern? You can then help to either comfort your client to understand there probably isn't concern here, or you can take them to the next step of intervention, which might be an evaluation or some type of treatment or consultation. So it gives you really a good level of specificity that you might not have otherwise, and the clients then know that it's coming from a place of information and understanding. The other piece I just wanted to add around the court preparation on the substance abuse piece is, again, I've often been involved when there have been testing, when there's testing going on and it's been drafted, and the testing protocol may not necessarily be appropriate for the alcohol or drug abuse problem. So, for example, there might be binge drinking as a concern, and the testing isn't happening the way you need it to happen to really report binge drinking. So they might only test for a couple of weeks, it doesn't capture the binge drinking episodes, and then the information is missed. So again, it's really helping you to kind of become more granular in exactly what you're asking for and what you need to ask for without having to hire an expert or without having to spend thousands of dollars and try to figure out what's best for this particular family. I'm going to shift over to an uncontested case and just the variety of cases that can come up here. One of the biggest things that I always look at for these uncontested cases is, there's often a lot of talk around the post-divorce planning, right? How are we going to help this family move into a healthy, functioning, post-divorce functioning unit? And the better that you can help them get there, the better off the family is going to be in general. And you hope that they're not going to return and the children can go off and, move into this new family unit. So again, by having some information on what does this family look like on a day-to-day basis. So for example, you have a child with ADHD. Okay, well, what does that mean for this family? How do I help to set up this family with this particular child to hopefully be more successful? And so there are ways to think about this family kind of centered around that psychological construct. So as an example, co-parenting. What are going to be the problematic behaviors of this child, and how do I help to create a co-parenting plan for this child? Another obvious place would be court preparation. It would be, developing a parenting plan for the family that's specific to the children in the family, whether it be the ages of the children, the particular special needs of the children, even just the temperament. You have a child that is a little bit more reactive and more sensitive to change, and just being able to use that information to create a flexible parenting plan for the family. Looking at it from a case management perspective, even if you have an uncontested case, there's always risk factors in every family. There's always vulnerabilities. Every family has them. So again, is there a way to look at those vulnerabilities and to kind of see them ahead? And to say, okay, well, we've got young children here, we can develop a plan, but we know, in a few years, there might be pushback on this parenting plan. Or, okay, we have a very involved, extended family unit. What is that going to mean for this family? Or there's infidelity. How long is it going to take to rebuild trust here? So, looking at those risk factors may help to kind of put in some extra language, or just even counseling the client around what to expect and how to address certain, expected problems that arise in those cases. And again, for a four-way meeting, it's just really using that psychological information to help guide around those topics. So instead of, not just focusing on the finances, but also focusing on the children, what's unique about this family, how do I help them to move to the next stage, and then making sure that's all crafted within that meeting.
One thing that I'd like to add, just to tie these last two slides together, is to really acknowledge and point out that this is a transformative way of practicing. It's shifting from, as we see it, really taking a reactive stance towards issues as they emerge and taking a very preventive, proactive approach, again, by starting with an intake sheet like the one that we described with the psychological topic areas, And you could even use that sheet just on the last illustration with looking at future risk factors. The basis for doing it this way is just as you would collect information on the financial piece of a family, just as you would analyze and look at the legal elements of the case. This is the same approach that you would take proactively with the psychological elements. And it doesn't require that you outsource all of these issues to a mental health professional to manage and respond to these. Really, a lot of these are simple, easy to access, easy to understand pieces of information. It's just integrating it into your workflow and planning client consultations around that information and helping organize that information uniquely to the family itself.
So again, I think from us, we sometimes are in this unique position to speak with clients around their experiences of their divorce and how things went, and what they ideally would have liked to have seen that would have been different. And I think for both of us, we hear regularly that when clients choose their attorneys, what made them choose that particular attorney, often they'll go back to there was something that was said, in that intake meeting, something that made that client feel like the attorney understood them or understood the situation, and it helped them to build trust. And so, in our opinion, by having more available pieces of information to connect with that client, to kind of say, I get it, I know what it feels like to have, a child who has autism, or I get it, I know what that experience is like, that you're concerned about your spouse's drinking. It allows that level of connection there, and then hopefully some trust, because that client control piece can be so important.
So what's in it for you to think about, to adopt components of this strategy approach to using psychological information? We came up with our top 10 list, and hope you will consider some of these factors. But essentially, it's really, as I pointed out before, taking a proactive versus a reactive approach. The advantage of that is it goes hand in hand with having improved client control, improved case control. So if you analyze the issues that are psychological at the onset of the case, you can predict the topics that need to be addressed, whether it's with services, whether it's with a stipulation, whether it's with a particular order, or if it's with a collaborative agreement that's reached. And by talking about these issues in an informed way can certainly raise the stakes and likelihood for having collaborative discussions and non-contested cases and bringing better and quicker resolutions to families. The other aspect is there's a myth that you bring in experts when there's a big issue or when the case is revving up for trial. And it's our belief that you can really address all of the small issues, which are sort of they may be the boring issues, but they're the ones that come up in a daily and a routine manner with these families, particularly post-judgment. So by identifying the special needs kids issues, the young kiddie issues, if a father or a mother needs to be more informed on a particular parenting set of responsibilities, if one parent was more involved than the other, these are little gaps that can be filled in effectively by taking this stance. For yourselves, it allows for deeper insights into all of your cases. All families have psychology as a part of them. They're all psychological issues, touch families in greater or lesser degrees, and this will help you be more informed about this. And this is a matter of knowledge not just being power, but knowledge really being everything, and being a leader within the field that touches upon psychological issues on every single client. The clients, of course, will be pleased by this because they'll have a sense of being understood with greater depth, and feeling understood creates better outcomes for them. Within the firm itself, people tend to take particular specialty areas and be the go-to person, whether it's on alimony issues or whether it's on co-parenting issues, and this is just another opportunity to elevate the collective intelligence in the firm. We also believe that this is an opportunity for new revenue channels, so you can really expand your portfolio of services proactively. So again, it's not meeting reactively on a psychological issue. It's saying, let's talk about the developmental issues with your children, and let's think about how to construct that in a parenting plan. Let's think about the strengths and weaknesses of co-parenting and such. This positions you to stay ahead of your peers And finally, to really connect with the clients at the emotional level. So this brings us full circle back to the beginning of our presentation where we talked about the disruptive factors that are present and how do you compete against that and how do you counterbalance to help your clients feel emotionally understood.
So I'm going to conclude the webinar just by bringing up a couple of points. I think that when we look at the court system in general, whether it's the civil, criminal, or family or juvenile court system, science is very much a part of every single court system. I mean, it generally will come in as being something meaningful to consider, just as the law is. I mean, it has a very strong foundation there. And there's a lot of push towards really integrating that scientific piece really across all the court systems. So, I think for us, it's really just trying to make sure that the information's available out there and that maybe it can be considered up front, used in some meaningful way, families to a better resolution. And so we're hoping that by trying to think about it, trying to create some tools and strategies around it, we can start to maybe do things a little bit differently and really help the clients, overcome this tremendous hurdle. I mean, divorce is so difficult for these clients. They're really in so much distress. And the court systems are really a difficult place for these families. So I think the more that can be done in your offices, the better. I mean, you really are in so many ways the gatekeepers for these families. And so it would be wonderful for them to have access to that information up front in a preventative way. So I'm going to open up for questions. We're going to let you have a turn if you have any. So please feel free to pipe in if anyone has a question.